very much in the first place for inviting us to talk to you today about the International Criminal Court. And of course, I will try to explain to you what the International Criminal Court does, why it was established, a bit of the history of the court, and the focus will be on the work of interpreters at the International Criminal Court. My name is Diederik Zanen. My function at the court is that I work for the Language Services section, and I'm currently the head of the Situation Languages Translation Unit. I've also had another number of functions within the Language Services sections of the registry. And among others, I've been responsible for the recruitment, the training, and the deployment of field interpreters. Interpreters that work not necessarily always at the seat of the court, but also elsewhere in the countries where the court is active. So I will talk to you today mostly from my own experience, of course, and also a bit about, mainly about communication at the court, how communication is facilitated across different cultures and across different languages, because this is a really, really important issue at the court. The court itself is composed of international staff. At this moment, and I'll specify this when I'm talking to you in October 2021, the court has around 1,000 employees from all over the world, from about almost up to 100 different nationalities working together to make this organization work. So we're talking about a court, which is also an international organization. It's established, its seat is in The Hague, in the Netherlands. And as you can see on the slide, on our first slide today, it's a fairly new building. It was opened in 2015, although the court was established a little bit earlier. This is what we call the permanent premises. And in the middle, you see the so-called court tower. It's meant to be transparent. It's made mostly of glass, as you see from the outside. And it's meant to symbolize the transparency of international justice, because justice, especially international justice, is not just there to be done, but it's also to be seen. So most of the hearings, for example, that are held at the International Criminal Court are public and can be visited. And we hope that we will have the opportunity one day or another to visit the court and see the court in action and attending a hearing. The buildings on the side are occupied by the different organs of the court, the registry, the language services where I work and where my colleagues work falls under the registry, which is the organ that supports all the activity and the administration of the court. And then we see on the left side the offices of the Office of the Prosecutor. And the prosecutor plays an extremely important role in building cases at the court. So let me continue. A brief outline of what I will be talking to you today. Why was the International Criminal Court created? To give you a little bit of context of that it didn't happen in one day. What makes it different from other courts? What makes the court unique in a sense? What is interpretation and why are interpreters needed? Which communicative events take place at the ICC? And with communicative events, I mean activities that take place at the court or in places where the court is active, where people communicate with each other. And that's almost any activity. And the interesting part, of course, for this presentation today is that this communication takes place between people with completely different backgrounds, and linguistic and cultural barriers have to be overcome. So this is one of the challenges that interpreters face, and I will go into a little bit more detail in this presentation about those challenges. And lastly, I'll talk a little bit about the cultural diversity at the court itself, the professional culture, and also the role that the International Criminal Court plays in protecting cultural heritage. Culture and language are really at the root of what the court is about. Lastly, of course, we will give you some examples from the field, and my dear colleague Jose Kukulu will give examples from his experience working as an interpreter in the courtroom. They will illustrate some of the challenges that have been faced and we're still facing in communicating across languages and cultures. So the International Criminal Court was established by a treaty called the Rome Statute, which was signed in 1998 in Rome and came into force after 60 states had ratified the treaty in 2002. So the court is, let's say, operational for almost 20 years in 2021. The quotes underneath the picture where you still see Kofi Annan, the then Secretary General of the United Nations, and the signatories of the Rome Statute. The quotes that you see under the picture are from the preamble of the Rome Statute and describe the ideal of the court. Why was the court established? It was mainly established to put an end to the impunity for the perpetrators of the most serious crimes of concern to the international community. And I'm going to explain you what type of crimes those are. Also, importantly, and in the preamble, it's mentioned how important cultures are. As you see, it says, all peoples are united by common bonds and their cultures pieced together in a shared heritage. And there's a concern that this delicate mosaic may be shattered at any time. And it's exactly the reason why the court has been established, that this delicate mosaic has actually been shattered, and in some places in the world, unfortunately, is still shattering because of serious conflict and crimes that are committed. So if we're talking about grave crimes that concern the international community, what crimes are we talking about? And these are the crimes that fall within the so-called jurisdiction of the court. The court has a mandate to deal with these type of crimes. The first one is genocide. It's a crime that is basically concerns crimes that are committed with the intent to destroy in whole or part a group because of religion, because of their ethnicity, or because of their political views. Crimes against humanity are basically crimes, that are also very serious crimes that are committed on a large scale against the civilian population, with a plan to systematically attack the civilian population. So we're talking about large-scale crimes, not isolated incidents, but usually crimes against humanity involve some type of government involvement, some kind of policy that aims at harming and aims at harming civilians. War crimes are crimes that are committed in the context of conflict, and are crimes that are already codified a bit longer than the other type of crimes. For example, in the Geneva Conventions, there are 4 Geneva Conventions. I'll not go into detail about that. Since the 19th century, there have been a number of conventions that describe which type of crimes, for example, the treatment of prisoners of war, or the mistreatment of prisoners of war in this case, persecution. It can entail many types of crimes that can be considered war crimes. It depends on the context in which they are committed. And the crime of aggression is a crime that was later added to the Rome Statute as a crime that falls within the jurisdiction of the court. And that deals with armed force used by a state against the sovereignty or the territorial integrity or the political independence of another state. Now, these crimes are relatively new in the legal sense. The concepts of crimes against humanity and genocide actually developed during and after the Second World War as a result of the mass atrocities committed by the Nazi regime and during the Second World War as a whole, and that triggered the need to address these crimes. They were such horrendous and on such a large scale that new definitions had to be found, and they were then later laid down in a treaty that established the International Military Tribunal at Nuremberg and at Tokyo. So the Nuremberg Tribunal dealt with crimes committed basically by the Nazi regime in the Second World War, and the Tokyo Tribunal dealt with crimes committed in Asia by the Japanese regime at that time. This is actually what you see here are interpreters working during the International Military Tribunal sessions in Nuremberg. And this can be seen as the birthplace of simultaneous interpretation through equipment. It was completely new at the time that interpreters interpreted in real time for the participants and the parties during the sessions of this tribunal. The languages that were used in this tribunal were Russian, German, French, and English. So this was the start. And it's also interesting to think about that the equipment was developed by IBM, and IBM was also the organization in which Geert Hofstede, well known for his cultural dimensions, later did his research on cultural differences. So coincidence or not, ICC, International Cultural Communication, even the abbreviation sort of fits. The development of interpretation and professionalization of the interpreters sort of kicked off at the same time as the development of international criminal law. So these developments go a little bit in parallel. After the Nuremberg Tribunal, it took almost 50 years before there was another international criminal court. It was not the International Criminal Court, but the International Criminal Tribunal for the former Yugoslavia, established after the conflict, during the conflict in the former Yugoslavia and its breakup. Also there was the International Criminal Tribunal for Rwanda was established following the huge massacre of taking place in Rwanda. There were over 1 million victims, people killed in the short time frame of about 3 months. This was also the tribunal where the first case of the first conviction for the crime of genocide was actually done. The Special Court for Sierra Leone was another ad hoc court where the first former president of a country, of Liberia, was sentenced to 45 years in prison because of crimes against humanity. Other crimes or other tribunals were, among others, the extraordinary chambers in the courts of Cambodia to deal with the crimes that were committed in the 70s, so longer time ago. And this is a hybrid court that worked with local Cambodian legislation as well as international legislation together. And the Special Tribunal for Lebanon also operated in The Hague and dealt with more like with terrorist crimes that were committed in Lebanon. Languages in all these courts played an important role. In the Special Tribunal for Lebanon, for example, Arabic was a working language for the first time in an international court. And the International Criminal Tribunal for the former Yugoslavia, of course, also had linguistic issues. And the main languages there in which interpretation took place were Bosnian, Serbian, Croatian. Now, Bosnian, Serbian, and Croatian, which at the time at the International Criminal Tribunal for the former Yugoslavia was also referred to as simply as BCS, because yeah, it could be considered as one language or different varieties of languages that are very closely related, but because of the conflict, maybe grew a little bit further apart. So even though most people speaking Bosnian, Croatian, or Serbian would understand each other quite well, still it was a sensitive issue to provide the right variety of the language also when people were interpreting for the participants in these trials or translating. So this sensitivity about language is partially linguistic, but there's also an element of cultural sensitivity. For example, an accused with a Serbian background would prefer a Serbian-speaking interpreter and not a Croatian-speaking interpreter, because even though communication might be possible between the two languages because the differences are not that big, there was also an element of sensitivity, of having the right and of trust in the right variety of language. And we see this as well at the International Criminal Court these days, these type of sensitivities, that dialects or varieties of the language are very important, sometimes to make sure people can understand each other better, but also because there is this sensitivity about language and people just like or prefer to have an interpreter or to hear somebody speak or talk to them in a language that they recognize as their own. So how is the International Criminal Court different from other courts? Well, first of all, it's a permanent court. It's unlike the other courts that I've just mentioned. The ICC is meant to stay. It doesn't address one conflict or one country, but it operates globally, and any conflict, any situation anywhere in the world can in principle be referred to the ICC on certain conditions. The ICC deals with, it's important to notice that the ICC deals with individuals, not with conflicts between states, but it's about individual criminal responsibility. And it's a court of last resort. That means that in the first instance, it's up to the countries where a conflict takes place to deal with war crimes, crimes against humanity, and the other crimes, if possible. But if a country is not able or not willing to deal with these crimes, then a case could be referred to the court. The crimes have to be committed in order to be handled by the court on the territory statute or by a national of a state party. So on the map here, the blue countries are at present the state parties. You see there are still a number of countries in the world that have not yet signed or have not signed their own treaty and are hence not state parties and not actively supporting the International Criminal Court, among which, for example, the United States, China, and Russia, some big players in the international community. And this limits sometimes the cases and the situations that can be referred to the court, because the ICC then has no jurisdiction because they're not state parties. So the ICC complements national systems and does not replace them. It's not something instead of a national jurisdiction. It just is a court of last resort. Very importantly, victims are at the heart and at the center of the the work of the International Criminal Court, and they can actively participate in the proceedings. And this is a novelty in international criminal proceedings, that victims can voice their concern and can be heard directly or through a lawyer that represents victims or survivors of the atrocities in court. So victims are heard, and for victims' voices to be heard during court hearings, of course, often this goes through the assistance of an interpreter that can voice those concerns in a language, or interpret those concerns and statements to the judges. The ICC is not to be confused with the International Court of Justice. This is sometimes the case, and that's why I would like to mention it. The International Court of Justice is also based in The Hague and housed in the Peace Palace. But the International Court of Justice deals with conflicts between states that are resolved. So it does not deal with individuals per se, but with, for example, border disputes. Or like in this case, and there is a link with crimes against humanity, and sometimes in the case that you see here, the State Councillor and Minister of Justice of the Gambia brought a case before the International Court of Justice against Myanmar to complain about the treatment of the Rohingya community. The Rohingya community is a Muslim minority in Myanmar that has been persecuted, and at this time there are around 1 million refugees in Bangladesh, and this case has also come to the attention, has also been referred to the ICC for criminal responsibility, but that's a different case. Nonetheless, it's interesting to see that a small country, actually the smallest country in Africa, the Gambia, has stood up and brought this case to the ICJ. Where is the International Criminal Court active these days? And of course, this can change, but how does a case get to the ICC? As I've mentioned, first, it can be that a state party to the Rome Statute refers a case to the ICC. It can also get to the attention of the ICC because of a referral by the United Nations Security Council, or the prosecutor of the court can initiate the situation. Firstly, we call, before a situation is a situation, and a situation has a specific meaning in the context of the court, it's called a preliminary examination. And a preliminary examination means that there's research done to make sure that the conditions are met, that a situation actually falls within the jurisdiction of the ICC. Can the ICC intervene? So are we dealing with crimes against humanity, genocide, war crimes, or a crime of aggression? Are the crimes grave enough? Are there no national proceedings already in course that are genuine? So is it addressed as a court of last resort? Are all other means exhausted? And are the investigations and into the crimes against humanity in the interest of justice? So if the answer is yes to all these questions, then the chamber of the court can authorize an official situation to be opened, and then investigations will follow, and the prosecutor will actively start collecting evidence to support a case. There's actually only a case when somebody is arrested, there's an arrest warrant, and there is a suspect that can be brought to The Hague for a trial. So at this moment we have 7 preliminary examinations, we have 15 situations, but they may grow, and they actually have been growing over time since the court was established. For example, today, and this is interesting, very recently in 2021, after a preliminary examination had been held in the situation to look at the so-called war against drugs in the Philippines, the prosecutor asked the chamber to authorize to open an investigation in this case, which was granted. So you see in the left top corner the relatively newly appointed prosecutor, Mr. Karim Khan, and an announcement made on the social media that a new case in the Philippines has been opened on the 15th of September. And this is a message on the social media disseminated by the court in the language that most people, or a lot of people in the Philippines, will be able to read and understand, which is in this case Tagalog. Now, many other languages are spoken in the Philippines, and that's the reality in many of the countries that the ICC is working. Usually there's not one relevant or important language, but there may be several languages that are important, or even many. However, in this case, Tagalog is a language that's fairly widely spoken, so hence the message is conveyed in this language in a way that lots of people might be able to access. Now, another case that's very recent, and that's at a later stage, because this is in the Central African Republic. It's a situation, but we also have a case in the Central African Republic. And this case is a case against Mr. Muhammad Said Abdelkani. And this is a suspect in the case, suspected of crimes against humanity, of responsibility, accountability as a commander of one of the forces involved in a conflict in the Central African Republic. He has been transferred to The Hague to see whether this case can go to the trial stage, and that's called confirmation of charges. So at this time, a confirmation of charges hearing is held, and this is announced, as you can see here, on a billboard in the local language Sango in Central Africa. And this is a way in which people in the local community can take knowledge of what is happening at the International Criminal Court. It's a way to make sure that also the proceedings are transparent, and that the affected communities, the people that are most concerned with the hearings and the trials in The Hague, that they know what's going on. And then another development is that very recently, also in 2021, we had a situation with a case against Mr. Dominic Ongwen. That trial is at a much later stage, and Mr. Ongwen was actually convicted and sentenced to 25 years of imprisonment following a trial of several years in which many victims told their stories, and in which the judges eventually decided that there was sufficient evidence to reasonably believe that Mr. Ongwen was guilty on many of the counts that were brought against him for crimes against humanity. Without going into detail, there were some elements in this case which were cultural, and that are also interesting to mention. For example, Mr. Ongwen had mentioned in his trial, or his defense counsel in this case, that he had been abducted as a child soldier, and later as an adult, therefore was traumatized and would not have been able to control fully, or could not be held fully responsible for the crimes that he was accused of. And this because of indoctrination, and there were spirits involved, so local customs and culture. This is called so-called cultural defense. Without going into detail, this did play a role during this trial, but in the sentencing, it did not did not seriously influence. It was taken into account, and it's important because that these things are mentioned during a trial, because it shows that the court hears the story from all sides, and also local cultures are taken seriously in that sense. But I'll move on to the courtroom. Here we see the judges. There are 18 judges. They're elected for 9 years, and they are in charge of making sure that the trials are fair, basically, and that they are conducted in a manner in which they ought to. They represent, those judges, they represent different legal systems in the world. So some of the judges may have a common law background, some may have a civil law background. Those are the two main legal systems in the world, but of course there are also judges and that are more knowledgeable of elements of Islamic law, of customary law, and other legal systems. So on purpose, this bench or the judges are selected to make sure that there's a geographical distribution and also a gender balance. As you see, there should be ideally as many men and women in this role. Now I'll move on to talk about languages at the court. The working languages of the ICC are English and French, but also the official languages of the UN, and those are Spanish, Arabic, Chinese, English and French I've mentioned, and the last one slipped my mind, but there are six UN languages. They're relevant for the court because some of the major, most important documents are being translated into these languages to make sure that the world allows the international community as a whole can take knowledge of important decisions of the court. What we call communication languages are languages in which the state parties choose to communicate with the court in their official communications. So that can be almost any language, and this has an impact on the court on the translation services that need to be provided by the language services. And the situation languages, those are the languages that we most importantly deal with, are basically any other language that is spoken in a situation country. And there can be many. And there are many challenges related to situation languages because, and I will show you in a little while, some of the languages are not widely spoken. There may be many terminology issues with the language. There are not a lot of equivalents that are easily to translate from one language to the other, etc. The need for language at the International Criminal Court arises from articles in the Rome Statute and in the regulations of the court itself. The accused and persons under investigation actually have a right to have free of cost the assistance of a competent interpreter and such translations as are necessary to meet the requirements of fairness. If any of the proceedings or documents presented in the court are not in a language that the accused fully understands and speaks. This is a provision in the Rome Statute. Now, in practice, in the countries where the ICC operates, for example, we've also come across persons that fully understand and speak a language in writing, but not verbally, or the other way around. And this is not really covered by the Rome Statute. These are things we learn in practice. So, what is interpreting? Just to explain you briefly that there's an important difference between translating and interpreting. These terms are often mixed up, but they're two different things. When we talk about translating, we actually talk about documents, document-based work. Translators transfer the meaning of one document into another language and produce another document in the other language. So it's document-based. Interpreters work real time. So basically interpreters convey the message. They cannot translate word for word, but it's about conveying a message from one person to the other. Persons that would not be able to communicate otherwise because they don't speak each other's language. So this can be done in several ways. We've seen at the Nuremberg Tribunal simultaneous interpretation through equipment was initiated. The simultaneous interpreting mode it already exists much longer, but not through equipment. And this simultaneous means at the same time. So simultaneous interpreters need a lot of training to be able to listen and produce what the other person says at the same time. And usually equipment for that is needed. Otherwise, it may get noisy in a room. As you see here on the picture, this is the setting in which so-called community interpreters usually work, and in our case, what we call field interpreters. They will be physically present during a meeting, and in most cases interpret in the consecutive mode. So that means that they take a pause after somebody utters a sentence or a couple of sentences. The person, the interlocutor, takes a brief pause to give the interpreter the opportunity to interpret the message to the other interlocutor of the conversation. So that's consecutive mode. Chuchotage is a means, it actually means whispering. Sometimes an interpreter sits next to a person. If, for example, in a bigger meeting, there's only one person that cannot follow the meeting in the language in which it's being conducted. So then an interpreter could be sitting next to him and literally whisper the interpretation in the ear of the person who requires interpretation. This is not very frequent, at least not at the ICC. And liaison is not so much a mode as a way of interpreting. For example, we have a lot of phone interpreting, interpreting via video link, and other remote interpretation, in which the interpreter is in one place and the interlocutor is maybe in another place, or every person in a dialogue, or what we may even call a trialogue, maybe is in a different place. So we could call that liaison interpreting. Here you see somebody talking in Sango, and of course without the interpreter, the message would not come across to the person he or she is talking to. At the ICC, and these are some of the communicative events that I talked about, some of the activities that are supported by interpreters that have a linguistic element. Investigators may need to go to the field to conduct investigations, to look for evidence, to interview survivors of atrocities, victims, potential witnesses. The defense counsel of an accused or of a suspect may need to travel to the field, or may need to have an interview with also with witnesses, potential witnesses, with parties to also to collect evidence, to find supporting materials for his case. We also have, importantly, a witness support and protection program at the court. There's a victims and witnesses section that deals with providing witnesses that come to testify at the court with psychological support and also with physical and protection for their security. In the cases that we're talking about, crimes against humanity, in many cases it's quite a risk that witnesses are taking, and they might be at risk of their security because of the people still being in power in the country where they're coming from, and in which they're going to test if they might testify against in court. So then they may need protection measures to make sure that no harm befalls them. Victims, as I've mentioned earlier, also can participate actively in the cases, and to participate they also need to get assistance, how to fill out forms, and how to make sure that their concerns are heard in and outside the courtroom. Outreach are all the public information activities to make sure that especially people in the affected communities know what's going on. We've seen the example of the billboard in the Central African Republic, and there are many other ways in which, for example, messages are conveyed about what's happening at the court through the radio, through television, through the newspapers, through meetings that are held in many different places. And in those meetings, clearly often a language barrier also needs to be crossed. And lastly, interpreters and field interpreters as well could be deployed or will do their work in the courtroom. But my colleague Jose will give you examples about how that works exactly. So what is the role of the interpreter? And how is this role actually perceived by other participants in these meetings? Basically, how we see interpreters at the court is that they are providers, that they're neutral and impartial service providers that know how to keep things confidential and that can be trusted, and that provide a full and accurate interpretation, conveying the message exactly as it was intended to the other party. However, in practice, when an interpreter is present during these meetings, physically present, there may be quite some pressures on this interpreter, on the role of the and these are pressures on the impartiality, especially, and on the neutrality of the interpreter. For example, when an investigator meets a potential witness in the field or potentially an affected community, the investigator may consider or may want to count on the interpreter as somebody to help him, may want to ask a question. For example, are these people telling the truth? Can I trust what these people are telling me? But it's not up to the interpreter to give an opinion about what is being said. It's the interpreter's role to convey the message and to be faithful to the message, whatever is being said and by whoever is being said. Because if the interpreter would give his or her opinion, then the interpreter would lose impartiality potentially, and put the conversation and the trust being put in the interpreter at risk. So for interpreters, it's also sometimes a challenge to convey the message exactly as it is intended, especially when this message conveys language which may be perceived as insulting or incorrect or undiplomatic or hurtful. And in that case, an untrained interpreter might change the message or modify the message to make it less hurtful or adapt it, maybe culturally to be better accepted by the other party. Now, this, of course, in a legal setting is quite a risk because it could distort the message, and it also takes ownership away from the people that communicate with each other. So what is the interpreter? The interpreter is maybe a little bit more like a mediator. Interpreters can, if possible, because they're not translators, do a word-by-word translation. They are interpreting. So that means that they convey the message in their own words. And this includes sometimes conveying also cultural references that cannot be literally translated or literally interpreted, but for which they have to find an equivalent. That's not an easy job. But interpreters are not parrots. That's sometimes how their role is perceived. For example, when a judge or when an investigator or an official says, just please tell the other person exactly as I said and as I meant it, then that cannot be a word-by-word translation, because that's not how languages work. Some languages have another word order, another syntax, another grammar, and it's often heard, for example, that there's no word in that other language. So then interpreters need to paraphrase and find a way to actually convey the meaning more correctly. So we call this eventually that the role of interpreters is to support communicative autonomy. And this autonomy is for the persons that actually conduct the conversation. Ideally, although this is not the reality, the interpreter is invisible. It's almost felt as if he or she is not there. But in reality, of course, these pressures and the presence of the interpreter is felt, and this role is constantly challenged. So this is a situation that interpreters need to manage. Now, quickly, some of the languages, some of the situation languages, so other languages than English and French, other languages than the official languages and the working languages of the court, that were relevant in some of the cases and some of the situations before the ICC are listed here. And as you see, most countries where the International Criminal Court has been active or is still active, and not all of them are listed, have several languages that have been relevant, in the sense that some kind of interpretation or activity had been needed, and communication in these languages needed to be facilitated. Some of the languages that you see here are what we call languages of lesser diffusion. We use this term not to say rare language, because we often tempted to refer to a language that we have never heard about as a rare language. But of course, languages are never rare where they are spoken. They are languages, so that's why we say languages of lesser diffusion. A smaller speech community, they can be spoken in a limited geographical area by not necessarily many people. Not all languages have a standard grammar, or sometimes not even dictionaries. And some of the languages that we've dealt with at the International Criminal Court, for example, in Sudan, there's a language called Zagawa, do not have a written form. They're not written languages, they're spoken languages only. So that means we need to communicate with somebody who speaks Zagawa, that the interpretation or the translations may need to be recorded and then made available to the other party as a recording instead of as a written document. So those are some of the challenges. And of course, as I've mentioned, a lot of terminology challenges are there with these languages. When we talk about legal concepts such as witness, prosecutor, pre-trial chamber, appeals chamber, there's a lot of these technical or these legal concepts do not have a ready equivalent in many of these languages. The same goes for example, when a psychologist meets a witness to see whether measures to make sure of the witness's well-being. I consider that they may need psychological terms like flashbacks or nightmares, and also these terms do not often have a ready equivalent in some of these languages. The same with technical, for example, witness protection measures. One of the witness protection measures is to pixelate images on a screen. Now, if we try to interpret this or to convey this message into Bitte or into Songhai, this poses a serious challenge to the interpreters, as you may understand. Now, some examples from the field before I round off. The linguistic reality on the ground is often more complex than it would look like at first sight. We see here a linguistic map of Côte d'Ivoire, Ivory Coast, where there was a case before the International Criminal Court that has led to to Laurent Gbagbo and Charles Blé Goudé. They were not convicted. That case was closed. But during this case, we had to look as language services into which languages were relevant to support the trial in these cases. One of the languages, for example, was Jula. Jula is, as you see, a language spoken in Côte d'Ivoire, but there are 72 languages spoken in Côte d'Ivoire, and not all of them are like B, C, S, from the same language family. Some of them are from a different language family and are completely not intelligible from one to the other. They're not mutually intelligible. So at the time that we had to look for support for these languages, it's important for the court to know where the conflict took place, who are the affected persons, the affected communities, where do the victims or the survivors of the atrocities come from, where does the court need to operate, and which language is spoken there. Now, in the case of Côte d'Ivoire, for example, we were aware that in some parts of Côte d'Ivoire, the language of Guéré was spoken. So we did our best to source, to recruit, and to train interpreters that could interpret and facilitate communication with speakers of the language Guéré. But what happens, as you can see, in a county or a geographical region like this, is that when, let's say, in the green area, this language is spoken, this language Guéré is spoken, that when you cross the linguistic border, which is of course invisible when you're on the ground, in the next village, which may have been in the orange area, where a language like Tura is spoken, which is of a different language family. So the interpreter that goes on a mission with the court to a green area and that crosses the linguistic boundary within the same country may encounter a situation in which they suddenly can no longer communicate with the persons to whom they need to speak. So they arrive in a different linguistic zone and even a different cultural zone within the same country. And this can happen. So this requires a lot of research in advance to make sure that people can always communicate with each other, and we depend on the local knowledge to facilitate this. Also, some of the languages may be referred to by the local population as another language than the name by which we know it. For example, the language Jula, which is fairly widely spoken in Côte d'Ivoire, in some village, people might say they do not speak Jula. They speak Odienekan, for example. Kan, the suffix kan in the word means language. So if the place is called Odiene, it means the language that is spoken in the place Odiene, and that's my language. So I call this language Odienekan. Now, it requires some knowledge to find out that this is actually the same language as Jula, maybe a local variety of that language, but still basically the same language. And even more complicated than that, we have encountered, for example, the examples of people that have said they speak Shaka Khan, the language of Shaka, and Shaka being the chief of my village. So I speak the same language as the chief of my village. That's why I call it Shaka Khan. So people can have different names to refer to a language than outsiders refer to that language. Or even linguists are used to refer to that language. Then in another example, in Mali, we have an active case. There are hearings taking place in the case against Al-Hassan, and we've had a case against Ahmad Al-Faki Al-Mahdi. who was accused of committing crimes against cultural property. Now, I'll end with that, but before mentioning the importance of cultural property and the protection of cultural property by the ICC, I want you to have a look at this map, which is an overview of a part of Mali, where you can see that there is the river Niger flowing through it. And why did I put up this map? Because there are some interesting features about two of the languages that are spoken in Mali and that are being used in the context of the court. One of them being Tamashek and the other one being Songhai. Now, for example, in the language Tamashek, one of the languages that is spoken by the Tuareg community in Mali, people living north of the river would refer to the north, actually, as the place where it is dry. The word they use is literally means there where it's dry, if they point to the north. Now, if this community of Tuaregs, and that's happened, moves across the river and starts inhabiting a place that is actually south of the river, the meaning of that word changes, because there where it's dry is now south and no longer north. So if you be lost in the desert and asking for directions, you better be aware of where it is dry, so that you're not moving north while you're meant to be moving south, or the other way around. So this is a cultural element that illustrates how important it is to have some understanding of the local communities and the local culture. And the other example from Songhai is that, for example, when people refer to a color, and in this case, it's the color green. The color green, for somebody living more eastward in Mali, they may have a color in mind, which to us is more yellowish, because the grass, if there's any, is usually dry and has a yellowish color. And the word used for green refers to the color of grass. Now, if you move more westwards, you see it becomes more green, but that would be, you would need to specify that the color green is the color of grass after it has rained, for example, or wet grass. So this can lead to confusion, of course, when in court a witness gets a question like, did you see the soldiers come to your village that then burned your house? And the witness says, yes, Your Honor, I saw that the soldiers came and they were wearing a green uniform. Then if then the uniform turns out to be more yellow, this yellowish, then this witness could be sort of considered as not speaking the truth, because the defense counsel might, for example, say, and this is a fictional case, this is not did not really happen, but it could happen, something like this, could say, well, the witness is lying or does not speak the truth, because you see, he or she said the soldier was wearing a green uniform, but here you see a picture and it's actually yellow. So these linguistic issues can cause some confusion and require some cultural knowledge. Now, the case against Al-Mahdi, and I think on this note I will end, was against the destruction of cultural property. Mr. Al-Mahdi was held accountable and actually pleaded guilty for being responsible of destroying shrines and monuments that were of real significance to the local community in Timbuktu in Mali. Now, the loss of cultural heritage to a community is a loss of memory, a loss of identity. It is really something which is at the core of the communities and of the society to keep it together. And that's why it's also now recognized as an important element in all other crimes, war crimes, crimes against humanity, genocide. The cultural element always takes a role, because when a community is attacked on their culture, and whether it's tangible culture like buildings or intangible like their language, like their music, then this destroys sort of the fabric of the society. It's something very serious. But this picture is beautiful. And why is it beautiful? Because after a case, there's a trust fund for victims. The trust fund of victims collects funds to support the rebuilding of communities that have been affected by these horrible crimes. And in the case of Mali, you see here a monument, a building that has been rebuilt, a building of big importance to the local community, that has been rebuilt with funds made available after the conviction decision of the judges. And yeah, you also see that the then prosecutor, Ms. Fatou Bensouda, went to Mali, met with the local community, with experts on archaeology and monuments. And altogether, it's a quite colorful picture and also a hopeful message, I think, for the future. It gives some hope that even though terrible crimes are committed, there is a way for the affected communities to get some form of justice and reparation for the harms that they suffered. So on this note, now I will end, and I will hand over to José to speak about interpreters in the courtroom.
Hello, everyone. My name is José Kukululua. I'm a court interpreter at the International Criminal Court. I joined the ICC in 2006 and mostly work as an interpreter for African languages, mostly Swahili and Lingala. So today I would like to share with you, of course, my colleague Dedrick Zahn has already given you the broad image of the court, the ICC, and also how the ICC is organized, the mandate of the ICC, how the ICC is organized language-wise. And I would like to talk to you today about the reality of being inside the courtroom interpreting during a hearing. As you know, and as you could see also, the ICC has got judges coming from different countries, different cultures, and not only judges, but also parties, the prosecution, the defense, and the participants, the legal representatives of the victims, all those who participate in a hearing, they have a diversity of culture in their backgrounds. And of course, we cannot forget one of the most important figure in a case who is the accused, of course, who has got the right, according to the Rome Statute, to follow their case in the language they fully understand. And that right means that the accused may not be knowing French or English, which are the two working languages, and know rather another language. So they have the right to follow the whole proceeding, the whole case in the language they fully understand. And of course, we have another figure who is the witness, who may be at the same time a witness and victim. In that case, we call them a witness with dual status. It means they testify, but at the same time, they have been recognized as victim in the case. So as you can see, the picture is quite a broad picture. I would like just to see if I can also share with you my screen. Yeah, so as I was saying, yeah, I will really be talking about the courtroom. So as you can see, the judges are sitting at the front row that is on our right side. And in front of the judges, you have all the legal officers who assist the judges. And we have as well the court officer, who is the person who is in charge of organizing the proceeding during the hearing. We have the usher, who is someone who helps. And also the parties and the participants, they sit on the far end there, that's the prosecution, and on the right side of the prosecution, the legal representatives of the victims. And then on this side, you have the defense team, and of course, and the accused. And you see one screen at the left side, at the left side, that's where the witness sits when they come to testify in the courtroom. Otherwise, they can testify by video link. And you can see also the gallery where the public can come and follow a hearing. And it is a public hearing. From time to time, they shift from public to private or to closed sessions. So as you can...
Joseph, is it possible that you can put the full screen in presentation mode?
Yes, I can do that.
Everything is fine, it's going well. We will just adjust here. Exactly, perfect. Please go on.
Yeah, so as you can see, the people in the courtroom, they represent really a diversity. They come from different countries, different cultures, they speak different languages. So how is communication made possible during a hearing? That's what I'm going to talk to you about today. And what are some of the challenges that are faced at the ICC when it comes to interpretation? So the first thing I will say that the ICC's interpretation system, the way interpretation works at the ICC is very complex. Why? Because it involves several languages at the same time. So the presiding judge in the case, the prosecutor versus Al-Hassan, can be speaking French, but then closer to him, there is another judge who comes from Japan who speaks English. And then on the other side, another judge who comes from Latin America or Canada who speaks English. So the witness speaks Songhai, which is one of the languages in Mali. And the accused himself also understands Songhai, but Arabic is his mother tongue, or Tamashek is his mother tongue. So you have to make sure that all these people, they understand each other. That is very difficult. Then if the witness speaks in Songhai, the Songhai interpreter, who is a French speaker, will interpret what the witness has been saying from Songhai into French. But then the Japanese judge and the Canadian judge who don't understand French, they need someone to interpret from French into English. So you have Songhai, French, French, English. And then the accused may have the right to follow what is being said. So there must be interpretation towards the accused and then Arabic. So in one hearing, you can have 4 languages that are activated. And that's what we call the relay. Because when the Songhai witness speaks, the English interpreter will wait for the Songhai interpreter to interpret into French before they do interpret from French into English. And when the judge who speaks English puts on a question, whether the judge or the prosecutor or the defense team in English, it has to be interpreted first of all into French, and then the Songhai interpreter will have to take from French into the Songhai. So you see how complex it can be at the courtroom. And this goes to one point, is that everything at the ICC, since the ICC is an e-court, everything that is said, everything that has been happens in the courtroom is recorded. Image is recorded, sound is recorded. And we have colleagues who also are called court reporters. So they have to write everything that is said in the courtroom. So it makes things very complex. That's why interpreters, as my colleague Dedrick said, they have to go through a training to prepare them to be ready to interpret, not in a conference setting where they talk about tomatoes, where you can make a mistake. Instead of saying tomato, you say avocado. So they can, it's not as serious as such. Here we are dealing about people's life. Someone can go in prison for 30 years just because there was an error in interpretation. So interpreters need to get trained. And then when facing a hearing, when interpreting during the hearing, one of the challenges is terminology. Legal terminology is not all that easy for someone who has to interpret for a witness who comes from a background where they didn't go to school. How do you say cross-examination to a witness who didn't go to school? So sometimes we interpreters, we have to paraphrase. We have, depending on who is asking the question. If it is the prosecutor and the witness is a witness called by the prosecutor, then we say, now cross-examination, it means the defense team putting question to the witness. We say, now the other side, okay, the other side, different from the prosecutor, is going to put questions to you. So this is cross-examination. If you have to say the private session, then you have to explain, to paraphrase. Now we are going in a mode where everything you say, people can see us, but they cannot hear what is said. This is private session. And apart from terminology, you have also cultural issues, as Dedrick was talking about in the case of Mali. How do you describe North when you are in Timbuktu? How do you describe South when you are in Gao? The two cities are separated by a river. One is in the north and the other one is in the south. And then, of course, I would like to talk about the cultural background. One of the big challenges is the cultural background, the non-verbal communication, the context. People who come to the courtroom, witnesses, they express themselves the way they do express in their community. And it's not to be taken as for granted that everyone understands them, especially if they use metaphor, especially when they use gestures to talk to the judges, to answer to questions. And of course, apart from this, we have also another challenge, which is the various type of witnesses who come to the courtroom. One witness can be a victim. It means, like the case of a lady who is there, she can be a witness who has never been to school and is coming to testify. So you have to make sure that the language that is used is a language that she understands. Another witness can be a protected witness who is a victim. So as you can see, the image has been blurred so that this person, this witness, should not be recognized. So when the interpreter is in the courtroom, they do interpret, but they cannot mention the name of the witness, even if they know how they are called, because this is a protected witness. And the way, the type of the language that the witness use, it can be quite difficult to understand. It can be a variant They can say, well, I speak Swahili, but which type of Swahili? Is it Swahili from the north of DRC or Swahili from the south of DRC? From the north of DRC, they say, to mean car, they say mutugari. And then from the south, they say gari or motoka. So you have the same word in the same country to mean a car, which differ from the north and the south. They can be using military language like jargon to mean something that you have to know the context that they are talking about. They can say, we receive bags of seeds. They use the word mbegu, but they don't mean seeds. In their jargon, in the military jargon, in their armed group, mbegu, which means seeds that you use to plant, can be bullets. So, and then let me give you some of the examples. Before I give examples, I would like to talk about the accused. As you can see there on the left side and the bottom, that's Mr. Ntaganda, who was one of the accused. The accused, they can ask to testify themselves. So once they testify, of course, they will be speaking. Mr. Ntaganda spoke Swahili. So he had to testify in Swahili, and we had to interpret what he was saying. And then he can challenge interpretation. He can say, I didn't say that. The interpreter didn't put it right. So we have to check and verify the transcription. We have to verify what has been recorded in order to respond to this challenge. You can have also a witness who is an expert. The judges can call a professor of psychology from Amsterdam University, from Fordham University, from Sorbonne University, from the University of Madrid. They can ask a professor of psychology to come and explain to them what are some of the consequences of someone who has been living in a war zone for a long time, or a lady who has been witnessing her children being raped in front of her and her husband being raped in front of her. Psychologically, how can this person, what are some of the trauma this person can go through? Then an interpreter has to also learn the terminology that is going to be used by this expert in psychology. The expert in psychology can be someone from the military. Then we have to learn military terminology. It can be someone who has been involved in hunting animals. So you have to learn all the tools and the weapons that they use to hunt animals in the forest. So you see, terminology wise is itself a challenge at the ICC. That's why, as I said before, an interpreter has to prepare themselves. Not always they give you the material that they are going to use. Not always you are aware about what they are going to say, but at least you can prepare yourself and put yourself in the context so that you can know that when they talk, when someone who lives, a witness who lives in Tombouctou, which is in the north of Mali, in the north of River Niger, when that person say that we were going towards the river, so you say we were going towards the south. When another witness who was living in Gao, which is a city in the south of Mali, so on the other side of the river, will tell you we were going towards the river, then you won't say we were going towards the south. You are going to say we were going towards the north. This is what we call the context. And of course, people will complain. Like last time in the Al Hassan case, the prosecutor stood up and say, Your Honor, I heard the witness talking about Sahara, which is the desert in the northern part of Africa. But the interpreter didn't say anything about Sahara. The interpreter say the north. Of course, the interpreter understood that when the witness says, yeah, we were heading, the building was towards, that building was towards the Sahara. Of course, the interpreter understood that the Sahara, from where the witness was, the Sahara is in the north. So the interpreter say the building was situated in the northern part. This is the context. And let me talk about the nonverbal communication. We have witnesses coming to the courtroom. Of course, they don't speak, but they just talk. They make gestures. Like a woman who came to testify against an accused, and she was saying that the accused raped her. And during cross-examination, of course, she was a prosecutor's witness. The defense lawyer said, "Madam, I put this to you. You are lying. My client doesn't know you, and my client never raped you." And the lady didn't answer verbally. She didn't say, what you are saying, I don't agree. She just clapped her hands, doing like this. And that's it. Culturally speaking, she knows she was answering to the lawyer who was from England, and she was from DRC, Congo. Of course, people coming from Congo will understand that this lady is telling the lawyer that I am so shocked by what you are saying. I cannot understand that you are denying the fact. That's what she said. But she didn't put it into words. And of course, neither the British counsel nor the judges and other people who are from the Congo could not understand what she meant. It means she has to verbalize. She has to put words in her non-verbal communication so that we can interpret what she has said. Another issue is what we usually talk about in this course is the prohibitive and inhibitive, cases in communication. A lady who comes from a rural area in the Congo, who is asked by the council to describe the rape. What did the perpetrator did to her? What did the perpetrator do to her? How did this rape happen? Can you describe, madam, all everything that happened? When it comes to describing penetration, it means that saying how the perpetrator took his penis and introduced in the victim's vagina. She cannot say that because she has in front of her people who are not women like her. They are male, people who are not, people who are not familiar to her. She cannot talk about her private part. She cannot talk about the man's private part. She cannot talk about her vagina. She cannot talk about sexual act, the rape itself. And when she puts a word or she says something, she will try to use the metaphor. Then the interpreter will understand that when she says, he put his body and put his body inside my body, the interpreter has to know that that's penetration. Then sometimes they will just keep silent and not say anything because they will be shocked. At times they will be asked a question and they will just look down and they respond by looking down. So someone who doesn't come from that culture, like the case of the British Council, will say, Your Honor, I can say that this witness is lying. From the beginning, I start putting questions to him. He is looking down. He doesn't face me, doesn't look me into the eyes. So this witness is lying. While to the culture of the witness, looking into the eyes of someone is a lack of respect. Even though the person is saying the truth, but you don't have to look into someone's eyes, is a sign that you are lacking respect towards that person. Then you have another case where a young lawyer, a lady who was putting questions to a witness who was a chief in the village where he came from. And having a young lady putting questions to him, he really had a problem to answer to the questions. He stopped. He didn't want to answer the questions. People could not understand. This is a cultural issue. He cannot understand that him being a chief, a traditional chief, a village chief, is having a woman in front of him. He is sitting, the woman is standing. The position itself is saying so much to him. So he considers himself to be inferior. The person who is talking to him is standing and he is sitting. And this person is a woman. So you can see how culture, how diversity, is portrayed during this setting that is the courtroom, and interpretation has to take place there. Interpretation has to run smoothly. It is a challenge. It's a challenge in a way, people, they consider their culture to be understood in the context of the court. They will talk to you because you are an interpreter, you speak their own language. They will try to address, they put them the question, and instead of answering and telling what they have to say to the judges and to the parties and the participants, they will ask you, they say, would you like to tell them this? And as an interpreter, you cannot be, a messenger. You cannot be, the spokesperson of a witness. You have to tell them to address the chamber. And then another, as I said, another challenge that interpreters face during courtroom is the material to which they are exposed. Not all the materials, are, easy to face. I mean, like images, pictures, photographs, videos of people who have been killed, bodies lying down, pictures of armed group people after a battle. They cut the enemies, some enemies' head, and they put their heads on the sticks, and then to celebrate their victory, they will take a picture with those heads put on the stick. And then the prosecutor or the defense will ask to show those pictures on the screen. And they will put the question to the witness. Witness, Mr. Witness or Madam Witness, would you like to tell me if you recognize one of those people whose heads are hanging there? This means the interpreter has also to see that. And at times, if they send that material before the hearing, while the interpreter is preparing themselves, the interpreter has to watch them. So after watching all these very tough images, very tough videos showing very terrific scenes, an interpreter can start developing, post-traumatic stress. I remember at the beginning when I started interpreting in the Lubanga case in 2008, every night I used to have nightmares because I didn't understand why, till the time I went to seek for help, which the ICC provided. I went to see a psychologist, and they made me understand that because I have been watching these images, I've been watching these horrific images, this has an impact on my psychology, on me. And that's why I was having those nightmares. And somehow the psychologists helped me to overcome and understand, but not only that, how to protect myself and deal with such images. And today, of course, you as a student, you will be dealing with interpreters wherever you will go to work. You are going to find people who don't come from your same culture, people who don't speak your same language as yourself. So the question is, how do we deal with this? How do we deal with such cases? How do we deal with such challenges? I would say the first thing is to be aware that the people you are interacting with, they come from a different culture. To try to understand that culture, to try to understand the context in which they come from, the context, their background, so that the interaction with them will be smoother. The interaction with them will be easier because you are going to understand that this is how I should address them. When they say something, it means this, because in their culture, that is the meaning. That is the meaning. In the Dutch culture, if someone says, well, before I make this job you are asking me, before I do this favor that you are asking me, I will need you to bring me some beans. So in the Dutch culture, someone who tells you that, you will really understand that they need you to go to supermarket, to Albertine or Jumbo, and buy beans to give them as, a present to say thank you to what they are going to do to you. But then if you come to another culture, like in a DRC in Congo, when someone tells you that you have to bring them beans, it means they are asking you to give them some money. It means corruption. So these are two contexts, the same word, but spoken in different contexts. They cannot mean the same thing. So understanding people's culture, understanding their background, understanding their values, understanding their body language, understanding their non-verbal language, how they communicate without words, then you are going to be able to deal with them. You are going to be able to communicate with them. And in the case of the ICC, to help communication between these people who come from a very different culture, very different background, and other people who come also for different background, but they can speak something and everyone can understand everyone. This is the big challenge that we face at the ICC. This is the big challenge that we as interpreters in the courtroom, we face at the ICC. Of course, when these witnesses come to the ICC, some of them is the first time they travel to leave their village to come to the Netherlands. The setting of the court itself, is quite challenging to them. They are afraid to talk. That's why the ICC organized a session that is called familiarization. It means before they go to witness to start their testimony, they have one day, they bring them to the courtroom and they make them visit the courtroom. so that they know who will be there during their testimony, what is their role during the hearing. So this is in the case of the hearing taking place in the courtroom here in The Hague. But now with the COVID, and not only the COVID, we have been facing cases where the witness cannot travel to The Hague. So they have to give testimony through video links. And the times we don't, not only the witness could not travel to The Hague, but the interpreters themselves could not travel to The Hague. So we have a case where a witness is on a location and the interpreters who are going to interpret what the witness is saying. Let's say in the case of Mali, the Alassane case, the witness is in a location, the Songhai witness interpreters are in another location remotely, and they have to interpret. Of course, they don't have the same setting like here in The Hague. You can have a power cut. They can have, no electricity. So the hearing will have to stop. The sound quality at times is not good. So they cannot hear very well the witness. And when it comes to challenging their interpretation, and they have to verify the transcription and the recordings, they don't have all the IT equipment to do the verification. So these are some of the challenges that they face, interpreters face, which is of a logistic nature, but still a challenge. Because if the parties, they want the transcript to be verified before they continue, because they say we need this for the next witness who is coming. So it means it has to be done as fast as possible. But if they are still having those challenges, this work cannot be done the way it could be done if they were interpreting here in The Hague. So to sum up, I will say that courtroom interpretation today is a real challenge. So many people like you students would really love to come and see what happens, how it happens. And my wish is that, as the COVID-19 crisis is going down, that in a few months, you may have the opportunity to come and witness what I have been saying here to you by visiting us at the ICC, at the HQ, and witnessing during a hearing how communication is happening between the people who are participating and the witness who is testifying in a courtroom. And of course, we will be having another session where all that my colleague Dedrick and myself have been saying that has not been clear to you, you will have time to ask questions, and we'll be more than happy to answer your questions. So with that, I end my presentation and thank you for your attention.